Welcome to Time Warner Cable's Local Edition. My name is Brad Pomerance. Our guest today is Mike Feuer. He's a member of the California State Assembly, and California made history recently. It signed legislation, the governor signed legislation called the Homeowner's Bill of Rights. Why don't you explain it, please?
Absolutely. Well, the National Mortgage Settlement, which dealt with the foreclosure crisis, put in place some basic rules for the 5 largest mortgage servicers in the country.
And set aside a huge chunk of cash to help those that went underwater as a result of some shady practices.
Yes, it did. $18 billion ultimately would be directed to California. In the meantime, though, California just became the first state in the nation to codify basic rules to protect consumers and at the same time to give the homeowner the right to go to court to enforce those rules in the event that their lenders don't follow them.
Let's talk about that legal right, because on the one hand, one could say we want to be able to allow private consumers, homeowners, to protect themselves in a court of law. On the other hand, there's a risk of shady, frivolous lawsuits. We've heard a lot about lawsuits being used as a weapon. Talk to me about how you balance those two interests.
You put the term correctly. We did have to balance those interests, and here's what we did. First, I should describe the basic rules that we put in place. Lenders will no longer be able to dual track their borrowers, which means on the one hand attempting to modify their loan, on the other foreclosing at the same time. Lenders will no longer be able to robo-sign documents, which means they have to have verification for the documents on which they base a foreclosure. And one of the biggest complaints we hear, lenders will now have to have a consistent point of contact for borrowers so borrowers don't get the runaround. Now, we had to deal with how to balance the competing concerns when we have the ability of consumers to take their lenders to court if they violate the rules. First, the violation has to be a material violation. It can't be incidental. It has to matter. Second, we decided that the remedy that a borrower could get while they're still in their home would be focused on getting an injunction, a court order, to keep them in their home and stave off a sale that was based on unlawful practices. They can't get money damages, but because the point is keep the borrower in his or her home. And then we said for post-sale violations, then the borrower can get damages. But we also limited the ability to get some basic attorney's fees. A court has discretion to order attorney's fees, but they're not mandatory. So as you can see, we provided some balance in terms of remedy, materiality, and so on, but a borrower has to have the right to say to the bank, you didn't follow the rules.
Is there a limit to the amount of damages they can receive?
Yes. The damages are limited to their actual economic damages. In other contexts, we say that a person who goes to court can get damages for emotional distress, for example. Those are not allowed here. The focus of the bill is keep the family in their home if they played by the rules, and only after the house is sold give them money damages.
Who has the burden of proof?
Well, the borrower, anybody who is suing, is going to have the burden of proof to establish that there was a problem in the first place.
And you believe that this bill will not create a system whereby litigation is used as a weapon?
No, in fact, to the contrary, what I anticipate is because we have these rules in place, that the lending institutions are going to take greater steps to assure they abide by the rules. The point of the statute is not to create litigation. The point is to create clear rules and a deterrent to lenders undermining the rights of borrowers.
Have you heard from colleagues in other states wanting to mirror California legislation? As goes California, so goes the nation.
I've written other laws that have had that effect. Not yet, but we just recently put this law in place. I do anticipate that's going to happen, though, because California is the only state in the nation that gives its borrowers these specific rights. And I guess that every state in the country is going to have their borrowers go to their elected officials and say, want the same thing.
His name is Mike Feuer, member of the California State Assembly. I'm Brad Pomerance. Thank you so much for watching Time Warner Cable's Local Edition.